Good afternoon and welcome to today's webinar. I'm Beth Hawley with the Arizona Association of Realtors, and we're proud to bring you these free broker brief webinars designed exclusively for Arizona Realtors. Today's webinar will be an open forum where legal and realty experts will answer the burning questions you submitted when you registered. Joining us today are Muchelle Lind, CEO of AAR, Scott Drucker, AAR General Counsel, Rick Mack, partner with Manning & Cass and star of Mack in a Minute, Holly Eslinger, broker and owner of Exclusive Homes and Land, and Duane Fouts, broker and owner of Above and Beyond Realty. Today's presentation will be about 35 to 45 minutes. If you have any questions during the webinar, please write them in the question box and we will try to get them answered at the conclusion. As always, today's webinar will be recorded and available next week on our website at aaronline.com. Welcome and let's get started. Muchelle, what is on AAR's plate?
Well, Beth, there's a lot on AAR's plate right now in all areas, whether it's zip form and e-sign support, education, preparing for the state convention, risk management, and the forms that we'll probably talk about a lot today, and of course our legislative efforts. This is the time in the legislative session where there's a lot of heavy lifting. More than half of the bills introduced have already died because they didn't move forward in time. And now both the Senate and the House are working to pass bills so they can be heard in the other chamber, and they have a limited time to accomplish that task. So everyone is working hard, including our Vice President of Governmental Affairs, Nicole Slavic, and all the members on the Legislative and Political Affairs and Legislative Committee. There are three bills that I wanted to tell you about that I thought you might be interested in. The first one has to do with unlicensed assistants, and that piece of legislation, House Bill 2067, is intended to clarify the tasks that may be performed by an unlicensed assistant. We're also working with the Department of Real Estate on revising the substantive policy statement in regards to unlicensed assistants to clarify that issue. The second has to do with mobile homes. It's House Bill 2072. And what this bill does is expand the exemption for when a real estate agent can sell a new or used mobile home. And essentially allows a real estate agent to sell a mobile home in a mobile home park, new or used, with certain requirements. And then the last one that I wanted to mention is the Forcible Detainer bill, House Bill 2237. And that's a bill that we've been lobbying, and it prohibits the state bar or any state agency from mandating specific forcible detainer and action forms. There was a proposed rule at the Supreme Court that Scott Drucker and Nikki Salgett drafted an objection to that would mandate certain forms that we believe are not as comprehensive as the AAR forms. So, Beth, there's a lot going on at the association today, and as always.
Great, Muchelle, thank you. Scott, I heard something about wire fraud and form revisions lately. Can you give us an update?
Sure. First of all, good afternoon, everybody. Thanks for tuning in. Yeah, two quick points as we get started regarding some things that I'd like you to know and keep in mind. First is, and I think that this is an important warning and something that you guys are probably already aware of, but we continue to get reports here at AAR that our Arizona real estate transactions are being targeted by hackers that are perpetrating wire transfer fraud. And it doesn't appear that this scam is going away. In fact, if anything, it's becoming increasingly common. And because the hackers, the perpetrators, they actually hack the email of the buyer, the seller, the escrow officer, or the agent, these fraudulent instructions that we receive by way of email, they look real. I mean, they appear to be legitimate. They'll contain details about the transaction that you wouldn't expect other people to know. So it can be very difficult to really recognize that the instructions are fake. And so I'd like you to remind your clients that they should verify emails they receive that convey wire instructions. Specifically, they need to confirm all email wiring instructions directly with the escrow officer by either just picking up the phone and calling the escrow officer or going in and seeing them in person and making sure that those wiring instructions are in fact correct. And I think that's very important because you don't want to see your money disappear. Second point I wanted to quickly mention is now that the revised residential purchase contract has been rolled out, we have 2 new form work groups in place, and both of those are going to get started very shortly. The first is we have a work group that's going to be drafting a solar lease addendum. We've gotten a lot of requests for this sort of form, and so we're putting a work group in place. Laurie McDonald is going to be the chair of the work group, and our first meeting is actually going to be on March 23rd, so it's coming up. The second is a work group that's being formed to revise the on-site wastewater treatment facility addendum. It may not be the most exciting form, but it's a form that hasn't actually been revised since 2006. So it's been a long time, and it is time to take a look at it. The chair of that work group is Jan Layton, and the first meeting is going to be on March 21st. So keep an eye out for the work product that will come from those 2 work groups, and hopefully it'll prove beneficial.
Thanks, Scott.
May I add one thing on the wire fraud?
Please.
If you end up being, this is Rick Mack, if you end up being the victim of wire fraud, if you report it to the authorities and the bank within 24 hours, for the most part, they can retrieve your money back. If it's more than 24 hours, the money's lost in the ether and you're never going to see it again. So if you're unfortunate enough to respond to one of those emails by mistake, jump on it quickly. You can unwind the transaction. Hopefully it's a no harm, no foul sort of thing.
Well, that's a silver lining. Thank you. So we are moving on to the questions our viewers submitted. Rick, Duane, and Holly, what are the most significant issues you have seen arising from our new contract?
Do you want me to start, Beth?
Yes, please.
This is Holly Eslinger. I think that the one issue that is coming up more than I've seen in a long time is the use of the old, which is not on zip form anymore, but the old as-is addendum that people have in on their desktop or something like that, and that is coming back. And I'm not sure exactly why, because our contracts are as-is contracts. So, but however, we're seeing a lot of these addendums being used.
You know, this is Duane, Fouts calling. It's I'm really proud of the work that the work group did, because we've not experienced a lot of issues of any significance at all with the new forms and new contract. Probably the biggest thing that I see from our agents and is dealing with the prepaid items that were removed from the seller concessions provisions. A lot of our clients are in the position where they would like help with their prepaids, and of course, if the agents are not educated on that fact, they end up having to swallow that when it comes time to closing, which is not something we want to see happen. So we're trying to educate our agents that if your client does need some help with the prepaid, so we have to insert some language to try to help them along with that. So that's the biggest thing I've seen. Other than that, it's been a pretty smooth transaction. So I don't know what AAR is hearing, what the legal hotline's hearing.
Yeah, from the hotline's perspective, I'm with Duane. It's a really good form. I'm really happy with it, to pat us all on the back. I think it's much better than what it was before, and it's pretty good before we started. The biggest issues we're having are, believe it or not, warranted items, and people aren't quite sure how to deal with it and what, in terms of the transaction, needs to be working and not. Short answer is whatever the condition is as of the date of the contract is what condition needs to be in that closing. We're seeing some buyer's agents, got a few calls on this, some buyer's agents are either using the old form intentionally, so they have the buyer's warranties to give them some level of operational satisfaction, or they're cutting and pasting the warranted section from the old contract, plugging it into additional terms and conditions and trying to get it that way. So we're seeing some of that. Buyers and sellers are free to negotiate whatever they want. I mean, you can't dictate this is the only form we're going to use if you're a seller, but you could certainly encourage it. So we're seeing the warranted items being pushed by buyer's agents, especially with some FHA financing, because you need some level of functionality with the HVAC, electric, plumbing, roof, so on and so forth. So we're getting some of that. We're also getting some confusion in terms of which BINSR to use, and well, where do I give notice of the non-working warranted items? And we have to explain to them, hey, that's not in the contract anymore. It's effectively not as is. Present physical condition is the language I use to kind of dissuade the as-is language. But we're seeing some of that, and I also have seen what Holly's talking about, which is people using the as-is addendum to bolster the contract. It's a belt and suspender sort of thing. You don't need the as-is addendum with the current contract because all the as-is addendum does or did was eliminate some warranted items. That's what we're seeing mostly. We get a little questions on the CFDs and how the proration works, a few questions on prepaids, but for the most part, the transition has been much, much smoother than I expected. We have not been flooded with calls like I thought we would be.
I've got to concur.
You know, it's really interesting because I thought that first week that we would see a lot of the old contracts and the people would have them in their car and they'd be using them, and I haven't seen a one. Every contract that's come in has been on the new form.
Same
But
here.
so it's, I mean, I'm really, really happy with what I'm seeing. But I am seeing the ancillary forms. I've seen the old BINSR used quite a bit. They just haven't quite gotten used to the 2-page instead of the 3-page with the warranted items. So that's still a little bit of, but I think that's a training issue. So.
And one point that I'd make in regard to warranted items, following up on Rick's comments, is before you put the warranted items back in the purchase contract, remember that there was a reason they were taken out. They were causing confusion. They were resulting in buyer and seller disputes. So before you make that decision and say, you know what, we're just going to put that back in, keep in mind the issues that we were having under the previous version of the purchase contract that led to the removal of the warranted items.
Great. So, Muchelle, what protections do we have against fake or inaccurate statements made by sellers or builders and those we represent?
Well, that's a good question, and fortunately we have a court case that addresses just that issue. And the case is called Aranki versus RKP Investments, and it was decided in 1999. And in that case, the listing agent had conveyed some information from the seller to the buyer about the condition of the property that turned out to be false. And so ultimately a lawsuit followed. The court, in evaluating that claim, held that the listing broker was not liable for the buyers for passing along the information that the seller gave him without proof that that listing broker knew or should have known that the information might be false. So the court case says a listing broker has no duty to the buyer to verify information absent a red flag that the information is inaccurate. Now that just brings up the issue is when what is should have known. And I think to determine what you should have known, you can go to the Arizona Department of Real Estate Substantive Policy Statement on verification of information. And what the Substantive Policy Statement says is that licensees are expected to take reasonable steps to confirm or verify information under circumstances where a reasonably prudent real estate professional has reason to doubt the accuracy or question the accuracy, or if someone questions the accuracy of the information. So, for example, if the seller says there's no known roof leaks and there's clear staining on the ceiling tiles, you probably not can't rely on that information. And the final issue that I want to point that I want to make in regard to that is you can't lie. If you know the client is not being truthful, then you need to make that disclosure. But first, I would sit down with your client and find out why they're not being truthful, talk to them about their liability, and then be very cautious for the rest of the transaction, because if they'd lied to the other party, they might just lie to you.
And go talk to your broker.
Yes.
Please.
Yes, absolutely.
Not the Facebook forum?
No, we don't want the Facebook forum to answer those kind of questions. Thank you. It's amazing what you see in that Facebook forum.
Yes, it is.
But yeah.
Holly, when a buyer cancels on the BINSR due to repairs discovered by the inspection, do they need to itemize the approved items?
Beth, I would say absolutely they want to itemize them, because just saying they're canceling because of repairs really doesn't give a true picture of why they're canceling. So yes, they would have to report it.
And I always just look to the language in Section 6J of the purchase contract, and I have it in front of me. It says, buyer shall deliver to seller a signed notice of the items disapproved. So yeah, you have to identify an item that you disapprove of, and that shouldn't be overly difficult. But unfortunately, if you don't list an item that's disapproved, as a buyer, you may not be able to recover your earnest money. So you're potentially putting yourself at risk. So the answer is yes, absolutely.
And what if they don't? What if they don't, the seller receives a BINSR that doesn't?
Okay, so sure.
Itemize it?
Yeah, and unfortunately that does happen on occasion. If that occurs, the cancellation itself is still effective. That language is clear in Section 6J. The contract is still canceled. But at that point in time, if the seller wants the earnest money, they've got to now issue a cure period notice. They're essentially giving the buyer an opportunity, 3 days, to go ahead and list a reason. If they do that, the buyer would be entitled to the earnest money. If they fail to do that before the cure period expires, at that point in time, they may forfeit their earnest money.
And point of clarification, that's for the new 2017 February
Correct.
contract,
Yes.
not the old one. The old one was a little bit different.
And thank you for the work group for putting that process in place, because I felt as a broker there were too many times where that provision in the contract, in the old contract, was used as a weapon.
Yeah.
And which it was never intended to be that way.
And we are seeing calls on that where people are saying, I don't have to give the reason, look at what this contract says, I can cancel without. And Scott's point is well taken. You can cancel, but you have to give a reason after a cure if you want your money back.
Right.
So there's a little bit of confusion about that tweak in the industry based on our calls on the hotline.
And what if the reason, or what if the repair isn't acceptable to the seller?
Well, we gave
I
the
mean,
title company absolute discretion to disperse the funds as they so choose, but typically, I change my mind. I don't want to take my money out of the bank account. I don't want to move after all. Those are not going to be good reasons. What I tell people, it has to be property related, area related, or value related. If you're in any of those three categories, you're fine. If it's something else, I change my mind, I don't want to take the money out of my account, no. You can cure them, and they have to give you a property or area or value related reason.
Mm-hmm.
Great. So, Holly, just a little bit of advice to new realtors. What's the biggest mistake you see new realtors make, and what is your best advice?
Oh, boy. I would say the one thing that new realtors do is overpromise. They just, they say, I'll just guarantee this. Or they'll use words of promising things that they can't promise. Or they'll work out of their area of expertise. That's the other thing that they do. And the most important thing that a new agent can do is to train themselves, get a lot of training. The GRI program is the best program that they can take when they first get their license. I know I did that 40 years ago. It certainly has improved over the years, but I totally recommend that the educational piece is going to be the most important thing they can do.
As a broker, we see this a lot of new agents coming into the business and the struggles that they go through to try to make it in the business. And one of my biggest things that I counsel with agents is that are new to the business. Number one, get a good mentor and use that mentor. Learn the business from somebody who's practiced the business, been a professional at the business, and knows what they're doing. And if that's not your broker, then find somebody in the company that's willing to mentor you. Yes, it's going to cost you a little bit of money. You're going to have to share some commissions with them for a while, but that's probably the best thing you can do. The next thing is do the GRI, just like Holly said. I call that the freshman level of entering into the business. And you can go on to your other designations, your CRSs, your ABRs, and so forth that are more the junior and senior level stuff that you can get into. And then the third thing is learn how to find new business, and that should be part of your mentor's help, because every time you close a client, you're unemployed until you have a new client. And so learn that process, learn how to market, learn how to become good at that aspect of it. And at the end of the day, keep learning. This business is forever changing, and you have to keep learning.
And I'll give you one that I think is probably very specific, but it's a mistake that I see made by newer agents, which is the belief that the seller's property disclosure statement is a document that's designed to protect the buyer. Sure, the SPDS is a great tool for the buyer, but really it's designed to protect the seller and to make sure that the seller is making all of their legally required disclosures. So the mistake that I see new agents make is condoning the seller's waiver of the SPDS, and when that's simply not going to be in the seller's best interest.
And all those points are excellent, and brokers really need to implement these kind of mentoring programs. In looking at our membership, 28% of realtors have been in the business 2 years or less. So that's a lot of new agents. So we need to be able to, as an industry, make sure that they have the tools to work professionally and with integrity. And my advice to new agents would be, don't be afraid to ask. Don't be afraid to ask a question. Nobody expects you to know everything about the transaction, and so ask those questions when you're not sure.
You know, I get that quite often, Michelle. As a broker, an agent will reach out to me and say, I don't want to bother you. I've called you all these times on this transaction. Please, that's what we're here for. That's what we get that's what we get up in the morning for, really, as a broker, is to help you as an agent get through the transaction. And honestly, we don't know it all either, but we have resources that you as an agent don't have. I can get a hold of the legal hotline, or I can get a hold of Michelle or Scott and go through some of the questions if you stump us. So please rely on us, use us.
Great. Michelle, is anticipatory breach still a valid reason for a seller or buyer to cancel a contract? And would a cure notice be required?
Well, the new contract didn't change the law at all in regards to anticipatory breach. And anticipatory breach happens when a party indicates that they're not going to perform a contractual obligation before the time for performance is due. That can be either the buyer or the seller. For example, if 2 weeks before the close of escrow, the seller says that he or she is not going to close on the agreed upon date, that's an anticipatory breach. And the case law defines anticipatory breach as when a party expresses a positive and unequivocal manifestation not to render required performance when it's due. So that's fancy words again for just saying, I'm not going to close when it's on the close of escrow date. So do you have to cure that anticipatory breach? Yes. Every breach under the contract requires a cure notice. So in that case, seller says he's not going to close on the close of escrow date. Buyer would have to issue a cure notice, give the seller 3 days in which to either rescind the statement that they will not perform and provide some sort of assurances that they're going to close on the close of escrow date. If the seller doesn't do that, then they are in breach of contract, and the buyer can pursue their damages after a mediation.
Thank you. Scott, if a refugee applies for a property you manage and they have zero background information, credit, or references, can you deny them? Okay,
so this question, I guess, touches on a couple different issues, and the first is, I guess the first answer is yes, you can. As a general proposition, you are allowed to deny occupancy to a member of a protected class as long as the reason that you're denying them is not because they're a member of that class. So can't be because they're a minority, because they fall into a protected class. You have to have another reason, which has to be a valid reason. But this is really a case-by-case analysis, and it can become a very complex issue due to something that's called disparate impact. And we've done some articles here at AR on disparate impact, and it's essentially a doctrine that results in unintentional discrimination, right? You've got a policy, the policy appears neutral, but for whatever reason, it has a disproportionate adverse effect on a specific protected class, a specific group of people. That could come into play in regard to this question on refugees. So, I mean, in theory, if you have political refugees from a specific country that are repeatedly denied occupancy because of a lack of credit, at some point, you know, I guess the government could step in and say, yeah, look, that's having a disparate impact on members of that nationality. I don't think that in today's political climate that that's likely, but that's something to be aware of. But I think the big picture here is, look, yeah, you can deny occupancy to a member of a protected class, but not because they're a member of that class.
And part two on the disparate impact issue, have there been any recent updates on applications for housing?
I guess the only update really goes back to, and Duane and I were talking about this previously, April of last year when HUD issued an opinion concerning how the Fair Housing Act applies to prospective tenants and sellers that have some sort of criminal record. And essentially HUD said a couple different things. The first is they said to the landlords and the sellers, look, you have to differentiate between arrests and convictions. They're not the same thing. And also you have to steer clear of blanket policies that restrict access to housing solely on the basis of criminal history. So you can't have a policy that says, well, if they check the box that says they've been convicted of a crime, no matter what it is, I'm not going to sell to them. I'm not going to rent to them. That's a blanket policy, and that would be prohibited according to HUD. So you've got to take a look. You've got to actually examine the situation. Not every crime is equal. Some crimes will indicate a risk to property or resident safety, and others don't. So you need to be very careful in regard to your screening procedures and give some thought to the effects that they have.
So what recourse, if any, do property owners have with tenants who filed bankruptcy in the middle of a lease contract?
I'll take that one. As a general proposition, filing a bankruptcy creates an automatic stay. So the landlord can't do anything with the tenant without getting court approval to evict them. Assuming you go through the process, you get court approval, you can evict a tenant for not paying, sometimes for past due rent. The flip side of that is leases are executory contracts, which mean they're continuing on. So in the bankruptcy context, tenants can say, yes, I'm going to stay, or no, I'm going to cancel. If they elect to stay, then the tenant has to continue to make payments on a timely basis post-petition. So the 30,000-foot view is effectively, yes, landlord, you have some rights. You will get paid if they decide to stay there. It's just going to take some time and some money to jump through the hoops.
And if you're a property manager, do you want to be advising your...
No.
Okay.
Once someone files bankruptcy, the brokers ought to just say, hands off. Landlord, you go see a bankruptcy lawyer and let's take care of this through them, because they're pretty significant penalties for violating the bankruptcy automatic stay.
Right. And I can also say that on a listing side, if you're a listing broker and your client files a bankruptcy when you're in escrow, same type of thing. You better be talking to an attorney somewhere, because it impacts your ability to collect your commissions as well.
And the flip side, landlords in bankruptcy, same idea. Go see a lawyer. I've defended that case and had some issues with it. So bankruptcy on either party's side, make sure you talk to counsel.
Yep.
So Duane and Rick, what happens if you have information that is incorrect in the MLS listing? For example, square footage.
It happens. Believe me, it happens. I think I read a statistic from the information market one time, who now does a lot of the work on the back end of Armless for correction of data in our Armless system. Something like 20% of all listings have inaccurate data in them, and that's amazing to me. But what happens? Obviously, you want to keep it correct, but if you don't, you have some liability, you have some exposure potentially, and I'm sure, Rick, you defended that case, right?
Yeah, and specifically square footage, because we all know the county assessor's records don't reflect reality. So if you're going to use the county assessor's records in the MLS, say 4,200 square feet per county assessor,
Yes.
that way you're identifying the source and you're not going to have any issues. A couple other points on square footage, if I could. Michelle hit it right on point. We have a right to rely on what sellers tell us. So if seller represents square footage, we may pass that along without liability, assuming there's no red flag. That's in terms of the civil liability side. What's a little bit different, and I'm wrestling with DRE on this issue now, is what happens with the regulatory side. The law is pretty clear. If you pass along information, even if it's false, not knowing it was false, brokers are for the most part insulated from liability. The DRE is not necessarily bound by the Aranke decision, so that's a bit of a struggle. So just because you don't have civil liability doesn't mean you don't have some problems, so make sure it's accurate. And one final piece, there's a case right on point interpreting our contract called Elm Retirement Centers. In that case, the court specifically says our contract, as drafted with all bold, all capital letters, shifts the responsibility to verify square footage to the buyer during the inspection period. So especially if you're a buyer's agent and your buyer is concerned about square footage, make sure you get it measured during the inspection period, not after.
So how about things like brand names? If the MLS says flooring is a certain brand, and then it turns out that it's not.
Same idea. If it's, I guess if somebody represents as a Sub-Zero refrigerator and it's a Frigidaire, then you're going to see it. That's going to be something that you can't escape liability from. If it's an obvious misrepresentation, you're going to have responsibility. If they tell you it's a certain brand of tile from Italy and it ends up coming from France, it's going to be harder to tag the broker with any responsibility on those.
Well,
so it's all a continuum.
And you're going to have some damages, right?
Right.
I mean, the difference in the brand would have to, from a civil standpoint, result in some sort of significant damage monetarily. So there'd have to be a significant difference in the price or value, right?
Agreed.
Doesn't mean you won't have to defend yourself, though.
No.
Exactly. And things like a jacuzzi is something that people use all the time. And like lots of tubs are not jacuzzi tubs. That's a brand name. PebbleTech is another one that the agents use all the time, and that is a brand name. So, maybe what I would do is I would talk to my broker about what names they suggest that we use in that case, especially in the listings.
So Scott, is there a boilerplate form or addendum for lease purchase transactions?
We actually get this question from time to time, and yes, Duane is shaking his head over there. The answer is no, and to be quite honest, I hope we never have one. Lease purchase transactions are difficult. They can prove problematic, and I don't think that you can really have a standard form, a one-size-fits-all. I think that would be a bad idea. If you have a client that wants to pursue this type of transaction, I think you have to get legal counsel involved. I think you need to go to your broker first and foremost, and then I think you need to recommend to them that they consult with legal counsel, and maybe it's an attorney that actually drafts the documents. Now, as for having the form itself, I do want to be clear that this isn't a staff decision, okay? This is a decision that gets presented to membership by way of the Risk Management Committee, and the Risk Management Committee's got to make a determination, okay, is drafting a form of this nature and providing it to our membership, is that going to be in their best interest? And repeatedly, the Risk Management Committee, and Holly, you're on that, has come back and said no. Having a form of this nature is not something that's going to help protect our clients. It's going to put them in harm's way.
Yeah, I concur with that. If I ran a brokerage firm, I would have a blanket prohibition, no lease purchase agreements, period, end of story. Just wouldn't let them do it. And the reason you typically want a lease purchase is because somehow the buyer's credit isn't good enough now. Well, guess what? Fast forward a year, their credit's not going to be good enough then either. So then you're stuck with somebody in your house. It's just a difficult situation, and again, I would recommend no. If you're going to do it, get to your broker, then get to a lawyer.
I will tell you, just as a side note, the largest litigation I've ever been in as a broker involved a lease purchase.
Yeah.
It was bad. It really bad, and you just don't want to go down that road without legal counsel.
I wonder if that's the same case, because I was going to say one of the biggest cases that I ever had was a lease purchase case. Yeah. And it was a very long, hard-fought case and cost everyone a lot of money. So,
a ton of money. Yeah,
so I'm also very adverse to a lease purchase transactions.
Just going to throw this one out to the room. In regards to estate sale property where the seller is not going to fix any items, warranted or requested, oh, I'm sorry, so not fixing any items warranted or requested, and the listing agent wants to make it clear should be.
Yeah, so I think it's asking whether they should use the as addendum in that case, and I would say the answer is still no. I mean, first of all, if you have an as is addendum, that doesn't mean that you can't agree upon repair. So to the extent that they want to send the message that we're not going to make any repairs, I don't think an as is addendum does that, because even when you have an as is addendum, you can still request repairs.
And it's no longer even applicable on the new contract, right?
Yeah. Yeah, absolutely. I would agree too. There's no reason to use the as-is addendum for that kind of transaction. You know, this even if the seller says originally that they're not going to make any repairs, that doesn't necessarily mean when push comes to shove in the transaction that they might decide that, yeah, it's worth making a repair or two to close the transaction. So, but the as-is addendum is not going to help you at all with that.
I see it in the MLS ever so often. It might be an estate sale, it might be, who knows what the situation is, but the seller's not going to make any repairs. And honestly, it's something that I think is a waste of space in your MLS, because at the end of the day, like you said, the buyer's going to do what the buyer's going to do, and the seller's going to do what they're going to do, and as long as they come to a mutual agreement, we should be fine. But anyway.
So Holly and Duane, what are the most prevalent issues facing smaller brokerages today?
Well, let me answer that one, because I'm a small broker. Interestingly enough, when I coach other brokers, the one problem that most of them are having currently is the supervision. What does it mean that they have to supervise, and what does it look like? So they're questioning their ability to supervise their agents, especially if they don't see them all the time. The other question that a lot of small brokers will have is, how do I train my agents? Do I send them to classes like GRI? Do I try to train them myself? What do I train them, and in what fashion? Is it once a month in my office meetings? What does it look like? So I would say the two biggest things that I'm hearing a lot of other small brokers are how to supervise and how to train.
Yeah, and I would concur that those are two big ones. Another one that I think a lot of small brokers struggle with is growing their business. I mean, the recruiting process is tough out there, and all the brokers want the best of the best, right? We all want the same agents. And it's hard to give agents an opportunity to, not hard to give them an opportunity to change, but it's hard for the agents to change. So I think recruiting is another one that they struggle with, and that whole process of it. And all I can say for me, what's been positive for me is being involved in the industry, having been out in the field, getting to know people in the industry, and that helps provide you with a reputation, good, bad, or indifferent, but hopefully it's good, and that agents will want to associate with you. So I think that's one of the other things that small brokers struggle with, which leads to your revenues and your bottom lines, which are all things that we all have to deal with. So,
you know, and I think one other thing that's so important that I'm finding, a lot of small brokers don't think that they need to be educated themselves. I think one of the most important things is, if we have well-educated brokers, we'll have well-educated agents. So I encourage all brokers to get as much education as you possibly can.
Thank you. So to wrap up the webinar, does anyone have any tips or closing thoughts?
I would say read the contract. Most of the answers to the questions you have are in the contract. Take time. Have your agents read it, right? Make sure, when they come to you, hand them a copy of the contract and show them where the answer is, because 9 times out of 10 it's in there.
And get your old forms off of your laptop and your telephone. Use the new forms so we're all singing from the same page.
Yeah, in fact, make sure that your agents know that they need to open a new transaction each time they write a new contract. If they open a new transaction, they will get all the updated forms. If they reuse a transaction, then those forms are not being updated. And that's the way we're finding that most people that are using outdated forms, that's the reason. So inform your agents about that issue and have them go to a zip forms class. There are a lot of things with zip forms, with MLS Connect, that they can learn to make themselves more productive in your office. So please encourage them to take advantage of that.
I think a lot of agents and a lot of brokers say, oh, I don't have the time. But I think you need to make time. I think education is the most important thing that you can do for yourself and your agents. So please get involved as much as you possibly can in the educational process.
Yeah, those are all good things. As a broker, I had a mentor when I first started in the business, and I espouse the fact that as a new agent, you should get yourself a mentor, somebody that knows the business and knows it well. And as a broker, I think it's important to find somebody that you can mentor with, that you can talk with. I know Holly does some of that. I know I do some of that, where I'm happy to help a new broker get their legs under them, get their company up and running. And there's plenty of business out there for all of us. So, find yourself a good broker that can mentor with you, and I think you'll be off and running as a company. Cool.
Great. Well, thank you for joining us today. Our next broker brief webinar will be on June 14th. Panel, thank you so much for your insight.
You're welcome.
As we end today's webinar, I want to remind you of our upcoming Arizona Realtor Convention, March 28th through the 31st in Prescott. If you haven't already registered, we encourage you to do that this week. We have an outstanding program that promises to be compelling, educational, and entertaining. So we hope to see you there. Have a great day.